You do. I'm sorry. I got one more.
Not at all.
How would you get this? How would you get the merits of this case to us promptly?
So there's two different ways that this court could think about doing it. So the first is, I heard a couple colloquies earlier today to suggest that maybe the states should sort of have to take some of the burdens on ourselves because, okay, some people move in, maybe that's just something that equity shouldn't care about. And it may be true, this is Hornbook equity, that in some cases states don't get complete relief for the harms that they suffered. We just have to eat some of the administrability burdens. But the merits have always come into that, because that is just about remedying a party's own injuries. And the strength of the ability to remedy our injuries is going to turn on a peak on the merits. This is partially Ohio versus EPA and building on Justice Kavanaugh's Labrador concurrence, where this court said you might have some states who really like a policy and some states who want to get relief from the policy, and how you reconcile those two things, who should get relief, who should benefit from the policy, will turn in part on a peak at the merits because we have a greater right to relief from it.
I appreciate that. How do we get to the merits fast?
This court could set supplemental briefing on the merits by an order tomorrow if it wished, specifically to say the federal government has proposed that states get less than complete relief in this case. We could not possibly think about giving the states less than complete relief without looking at the merits.
Okay.
We want briefing.
Put that aside. Assume we've just got the remedial question before us, and we're going to decide the remedial question one way or the other. Then what?
Oh, then I share some of Justice Kagan's concerns from earlier that it would rely on the United States.
I appreciate you share those concerns. How would you address them? How would the states plan to get this case to the court promptly?
I think it's very hard to think about how the states would lose this case given the state of Supreme Court precedent. It creates very weird incentives on the certiorari docket when there's already binding precedent from this court. We do suffer harms from the application of this executive order beyond our borders that we need relief from. If we don't get a full remedy from that, I suppose we could ultimately seek cert before judgment on the basis that we still have Article III injuries that we're suffering, but we'd be asking this court to grant review from a circuit precedent we won on the basis that we have continued injuries. It's not impossible. This court knows best when it grants cert and when it doesn't. I would think it's not the cleanest way to tee up a case historically, and so it would raise some real concerns to the colloquies earlier today about how this case would ultimately come before this court.
Are you telling us that we really can't decide the question that we asked to have briefing and argument on without taking a peek at the merits?
So I'm not saying that at all. So there's two different ways to think about this case, Your Honor. One is to say, absolutely, the states need to get complete relief for their injuries, and then let's figure out the best way to do it, and we think the alternatives are not workable and not legal. If this court is going to entertain giving us anything less than full redress for all of the Article III injuries we bring before you, I don't see how that can be entertained without a peek at the merits, because you always look at the merits to decide should we get 100% or 90% of our own injuries redressed.
Well, would a decision